Hello ladies and gentlemen, welcome back to this series of videos that I'm doing on the occulted powers of the British Constitution. We're going through all the important aspects of the Constitution using this document, and we've just dealt with trial by jury as the main mechanism, and we're now moving on to this section, the Legislature, the government's limited jurisdiction, which is really explaining clearly as to why it is that the government's own law-making mechanism, the Legislature, is fundamentally limited in its powers, because the government is limited by the Constitution, therefore its own law-making mechanism must also be fundamentally limited as well. So let's get into this. An important revelation stems from the understanding that the people have the power to create law through the jury, and that that law is a higher jurisdiction than government-created legislation. The only law that the government is authorised to create under the Constitution is legislation, that which is now formed through Acts of Parliament in the Legislature. This is what most people think today think of as law. Okay. Now, one thing that's important to say on that is that people think that Magna Carta is powerful because legislation or Parliament didn't exist back then. No, that's not the reason. Magna Carta is powerful because it's constitutional law. The king was always able to create legislation. Just because Parliament didn't exist at that point, the kings created statutes before Parliament existed. So that's an important point just to make. Carrying on. The Legislature is considered one of three branches of government, the other two being the judiciary and the executive branches. The Legislature in Britain is Parliament, made up of the two houses, the upper house being the Lords and the lower house being the Commons. Legislation, as we know from the above, can be discarded through the power of the people, through the petit jury of 12, a court de jure. Due to those limitations, government can alter the constitutional framework in which it sits. Government cannot alter the constitutional framework in which it sits. I misread that, so it's quite important that we actually just make sure that's clear. It cannot write itself into a higher authority, and certainly cannot use its right to write legislation in order to alter the very constitution that binds it. It can, however, alter or throw out legislation itself, since that would have been created by government. So it's really important to understand that. A current administration can alter or repeal any prior legislation that a government has put in the past. It might be difficult to do so because of the Lords, it might throw it out, there might be extra hoops to jump through, but nevertheless they can fundamentally do that. Okay. Therefore, what that shows is that legislation itself is not long-lasting. Yeah, it's fundamentally quite limited law. It's not really law at all, okay, but the fact remains is that no legislation binds a future government, which shows that the legislation that they create is quite transient. It just comes and goes. Yeah, some of it stays on the statute book for ages because it might be quite good statute, but it doesn't have a right to stay on there always. Yeah, a government can always repeal or amend it. Carrying on. It is also important to understand that a further mechanism of control placed over the Legislature is that of ratification by the monarch. All Acts of Parliament must be ratified by the head of state, who in turn is bound through the coronation oath not to ratify Acts of Parliament that are repugnant to, breach or are incompatible with the 1215 Magna Carta. Other powers of the head of state exist, such as the power to dissolve Parliament and the nomination of the individual to form a government. In reality, more an administration. Yes, it's not so much a government as such, but an administration. Okay, so here's a quotation from Ken Dewdney from his book Democracy Defined, the Manifesto. As distinct from supreme constitutional customary common law, statute law is written law passed by the Legislature, which is Parliament or Congress, and enacted into law on its passing by the head of state. Whereas constitutions are permanently binding, statutes do not bind subsequent parliaments and cannot form or be part of a constitution. That was the point I was just making earlier, and it makes it beautifully. Okay, so that's from Democracy Defined, the Manifesto, do get a copy of that if you haven't already. So I hope that makes that clear. Carrying on. It is also important to keep in mind that no Parliament or Legislature made the original Magna Carta of 1215, as no Parliament existed at that time. The Great Charter is the people's perennial compact with the heads of state and can therefore never be considered a statute, though it is sometimes erroneously referred to as one. As Ken Dewdney states, this is either through laziness, ignorance, or a more conniving attempt to confuse and miseducate. I think that speaks for itself, but yeah, that's pretty important. You can see that the 1215 Magna Carta there is not statute. It's part of a promise. It's part of a peace treaty and an agreement on the part of King John at the time. Yes, he was coerced, quite rightly so, and we'll get on to why that was later. Okay, but it was quite correct what happened. So yes, that's binding on all future heads of state. Carrying on. The act of legislating new versions of Magna Carta in 1225, and there are others actually, by the way, there was one in 1216 or 17, can't remember, 1225 and 1297, which was the Confirmatio Cartarum, that's the Edward I statute, could only have upheld or pointed to the authority of the constitutional principles already held in the 1215 Great Charter, but could not diminish them. To claim that Parliament is sovereign by suggesting the act of legislating gives the government the authority to alter those constitutional constraints in which it is bound is ludicrous and absurd once the aforementioned limitations are understood. To attempt this is to be acting ultra vires, outside its authority. The government is either all-powerful, and therefore tyrannical, or the truth does indeed stand that the British Constitution rightly limits government powers. There is no middle ground. Okay, so it's basically saying that the statutes, the statutory versions of Magna Carta that they claim, they are literally only they're kind of like manifestos of the king, actually, is how they functioned at the time. And they are actually just statutes. But they are signposting, actually, to the 1215 Magna Carta and the Articles of Common Law within it. Carrying on. The legislature, therefore, contains perhaps 3 layers in total. The bottom and beginning of the legislative process is the House of Commons, or the lower house, in which an Act of Parliament for the creation of a statute begins in the form of a bill. This then proceeds to the second layer, the upper house, the House of Lords, to be passed or not, or sent back. It is important to understand the purpose of the upper house, as this is especially topical right now, during a time of yet more calls for reform of the House of Lords. I think actually that was at the time that I wrote this document, which was about 2 or 3 years ago. There was more stuff going on in there, more damage being done to the House of Lords. Unfortunately, this clamouring for reform is occurring against a backdrop of misunderstanding in the general population of precisely why the House of Lords consists. I thought it said exists. Consists and has consisted to a greater extent in the past of non-appointed permanent office holders. So this is talking about the hereditary peers and why they're actually very important. The Lords, who appear to the public as anachronistic, privileged and out of touch, are actually there as a protection mechanism for the people against the machinations of the politicians of the lower house. The dangers of untrustworthy and dishonest ministers who listen rather less to their constituents and more to the agendas of the whip are well known. Politicians who might later enjoy lucrative positions in industry and big business due to having only recently perhaps been instrumental in passing useful legislation beneficial to those same corporate bodies onto which they will be moving, occurs only too frequently. Yeah, so this is explaining all of that business of you scratch my back, I'll scratch yours, and I'll see what legislation we can get through the statute books, right? The problems of the backhanders and special interests of those who too often describe themselves as in power as opposed to in office are precisely why the upper house exists, containing those who are harder to bribe and hopefully might have a greater resistance to unscrupulous and dishonest dealings. A lifetime appointment, or even to a greater extent the burden of a multi-generational family responsibility over title, will bring with it reputational concerns too. There is a solemnity and gravitas that comes with a long-term responsibility, and the intention was always for these men of the upper house to temper the short-term agendas and the transient interests of those who could be more easily bribed. You can see what this is all about. So it's describing there the point of the upper house and how their long-term offices and long-term responsibilities were really all about removing them from that day-to-day politics, right? The purpose of the lower and upper houses could perhaps be equated to short and long-term interests of the country, the immediate concerns of the current administration balanced against the long-term fundamental character and freedoms of the realm. The people of this country had better understand this well and quickly before any more damage is done to the House of Lords. It is easy to see why the here today, gone tomorrow politicians of the lower house would rather the checks and balances on them were removed. That's really important to understand that. The reason for the third tier of the legislation is similar. The existence of the monarch's power to give freely the assent or dissent to a bill of parliament. The power of the head of state to ratify or not parliament's legislation is critical, and this has now essentially been lost by the gradual shift towards the erroneous belief that the monarch is obliged to ratify all legislation, thus morphing the head of state merely into a ceremonial figure. And it's not supposed to be like that. This is another cataclysmic loss of protection for the citizens against the tyranny of the legislature. Instead of calling for the increasingly politically correct course of removing the ancient long-term powers of these officers, it would be advisable for the sake of the liberties of the citizens to do the opposite and to understand the importance of these protections and balances built into the country's constitutional framework. Okay, so I hope that explains exactly why it is that the upper house is there as a constraining mechanism on the lower house that are politicians. Okay, we know what, it's interesting how people argue, well, the politicians are important in the lower house because we vote for them. Well, yes, but we're also very good at pointing out the limitations of the voting system and the fact that our politicians are not actually that trustworthy. That's the whole point of putting these long-term offices into the upper house. They're there for a good reason. And then the king is meant to be encouraged to use their prerogative, which is this idea of refusing to ratify legislation if it is not constitutional, if it breaches the liberties of the people. That's the whole point of these different layers of the system, because we know that politicians can't be trusted, right? So therefore we need those mechanisms in place, right? And the ultimate responsibility is the head of state. He can't have legislation, or is not supposed to have legislation on his statute books, okay, that is unconstitutional or would be breaching the freedoms, the free will of the people. Not supposed to be there. It's unconstitutional. Yeah. So I hope that section nails that one down for you. I hope that makes it nice and clear. So join me in the next section on democracy, a return to its proper meaning. That's where we're going to go next. Okay, cheers for now.